piece of incorrect information that we heard today, that this theory of the case was never put before Donald Trump until the closing of the jury. I have here, not only do we have the response to Bill of Particulars, I have the opposition to the motion to dismiss November 9th, 2023, putting forth, may I have the middle Russian doll, please?
This one?
Here it is. Look at the document. The Russian doll is in the document.
Not true.
Here it is, page 25, please. These actions violated Elections Law 17-152, conspired to promote the election of a person to public office by unlawful means, including FICA, the falsifying the records of other New York enterprises, and mischaracterizing the nature of the repayment for tax purposes.
Introduce documents into the record.
May I?
But I would,
I didn't ask to introduce it.
The gentlelady.
May I return the Russian doll?
I have unanimous consent.
Gentlewoman's recognized for unanimous consent.
Thank you, Mr. Chairman, and thank you, Mr. Eisen, for the demonstration. Unanimous consent, please, for, this is an article, ABC News, a timeline of Donald Trump's election denial claims which Republican politicians increasingly embrace. ABC News.
Without objection.
Thank you.
Mr. Chair,
Recognize the gentlelady from Vermont.
I ask unanimous consent to enter into the record people's response to defendant Donald J. Trump's April 27th request for a bill of particulars.
Without objection. Now recognize the gentleman from Oregon for 5 minutes.
Thank you, Mr. Chair. Professor Foley, do you want to respond to the rant we just heard?
Yeah, if I may have this back. Okay, so this opposition to the motion to dismiss, also he gives one page out of context. That paragraph that he was pointing to, these actions also violated election law section 17.152. In other words, it's just regurgitating exactly what they said in response to the requested bill of particulars, that the underlying offense, the first predicate, could be one of 4 different statutes, all of which are very, very different and do not provide adequate notice to a defendant, because this is an element of the crime. You have to be specific about elements of the crime. That's what the court said in Shad.
So if I may, thank you for that
That's why there's a due process problem.
And to your point, the complexities, I think, many times are a nuisance to those who disagree with you, Professor. So thank you for the detail that you share. Also, folks earlier on the other side of the aisle suggest that this hearing is not necessary because it was a state court, and thus this committee, being Congress, shouldn't be saying anything about it. Perhaps you can address that for just a second and explain why, in your opinion, you think the federal government should be concerned about what went on in Alvin Bragg's district.
Well, I mean, look, as the Judiciary Committee, and I assume the Oversight Committee also would have legitimate legislative purposes for looking into abuses of power by state prosecutors to violate anyone's constitutional rights. And that would include, intimidation based on gag orders, First Amendment violations, due process violations, equal protection violations, all the ones we've talked about are ripe for investigation by this committee and others.
And in fact, if we didn't, we'd be derelict in our duty of when we see a former president being drawn into this circumstance, we would have to ask ourselves, come on. So thank you for that. Commissioner Traynor, same question to you. Is there a federal reason for us to be looking at a state action such as we observed in Manhattan?
Unquestionably, there's a reason for this committee to investigate this, and it goes back to my opening statement where I talked about the fact that the Department of Justice did not zealously represent the United States in this particular case to go in and defend the jurisdiction that this Congress has given through FICA to the Federal Election Commission and to the Department of Justice to prosecute those crimes. Instead, they abrogated that to a local official to prosecute.
Right, and the question would be, and quoting the professor from earlier today, to prevent the fractured application of the law, disparate justice, double, triple, quadruple standards. This is what we're trying to avoid by bringing this issue up at this hearing. Is that correct?
Absolutely. You can't have 50 different standards of what violations of federal election law. It would apply to every member of this committee. It would apply to presidents, former presidents. If we're allowed to investigate what goes on in campaign finance spending under the guise of how 50 different states interpret it, we'll never have any equal protection for any individual running for political office.
Right, and you would think that those on the other side of the aisle would recognize the danger of opening this Pandora's box, so to speak. Let me go to another point. Anybody that's tried a case, and I've tried many, recognizes that the jury process is imperfect. It's a great system, but we have this thing called an appellate court because it's known that mistakes will be made. And the idea is once they are, you'll get another shot at it in the appellate court. Yet here we are, we know this is going to be appealed. But we're holding this hearing today. Why is this hearing important when there's an appellate process available? Go with you, Professor Foley, first.
Well, I mean, again, I think you have a responsibility to determine, for example, whether or not, federal funds are being used to further lawfare that is designed to be election interference. I think you have a responsibility to make sure that the civil rights laws, Section 1983, and other federal civil rights statutes are not violated by state prosecutors, especially for purposes of political interference. And, at the end of the day, judicial process, even though there's a trial, judicial process is not due process, right? Otherwise, we'd never have any reversals based on due process. You can have long, elaborate trials with lots of witnesses and lots of documents. They have them in Russia and Venezuela all the time. And they look like trials, they kind of smell like trials, but they're not due process-based trials. And that's the error that occurred here that I think ultimately was going to lead to reversal.
Yield back.
Gentleman yields back. The gentlelady from Texas.